Lordship, may I permit to mention this is for inclusion.
Pardon?
This is for inclusion.
Mention on Thursday.
Uh,
See the caption which we have given in the list.
Lordship,
Mentioning on Mondays and Thursdays. Yes.
okay. Okay.
Yes.
Lordship, leave may be granted to file a WPCT without certified copy. We have applied long back in 17th June. We are yet to receive the copy.
When did you apply for certified copy?
17th June, Lordship.
To get it, you will get it, certified copy.
Till now, it's not. Department is insisting. Kindly leave me granted to file.
Department will be giving. Department is there to work for all.
But
You
as of
take information in the department. If you find any difficulty,
Central Administrative Tribunal, Lordship.
oh, tribunal.
CAT, CAT.
No, no. WPCT.
WPCT.
You are appearing.
No.
What is the urgency? Tell us.
Urgency is that the penalty order has been stayed by in the interlegal
Union of India.
Yes, Your Lordship.
Penalty order stayed.
Yes.
And
GSI. I am appearing for GSI, Geological Survey of India.
Reinstatement order was there.
No, not reinstatement. Only the penalty order was stayed.
What was the penalty?
1 grade down of.
What is the urgency?
There is no urgency.
Get the certified copy. Yes.
Your Lordship, may I be allowed to mention Andaman matter, Your Lordship, which was due to appear
Yes,
today?
yes. Because
I've given notice. First week of September.
when was
It was due to appear today, Your Lordship.
no, there had been some miscommunication.
Your Lordship, they were not able to find the orders, last orders on the server as a result of which.
Have you spoken with your friend?
Your Lordship, I've informed them if it could be in the first week of September. I've given notice to all.
First week of September. No, that
Attorney General would be appearing, Your Lordship.
no. Then the petitioner.
There are four matters.
Whatever it may be, but the who is the advocate appearing for the petitioner?
They have a local counsel as well, and they are appearing from Chennai. So may I come back tomorrow then again?
Yes, you please make an attempt to contact them and you decide a date and
Your
tell
Lordship.
it to the court. We will.
Your Lordship.
As the Attorney General would be appearing and outstation lawyers will be appearing.
Both sides are outstation.
Please talk and inform us.
Your Lordship.
Yes.
I'll inform the court officer.
Yes, yes. Tomorrow morning you tell us.
Your
Tomorrow
Lordship.
is a Thursday.
Your Lordship.
You can request them to come also. We can.
Your Lordship.
Yes.
My lord, may I be permitted to mention one matter? My lord, one
Today is
assigned.
not the mentioning date, sir. See the list. Yes, call the list.
Item 1, I appeared for the petitioner, Income Tax Department. But in this matter, I have filed an application for amendment. Your Lordship, application for amendment of the writ petition, and that I have filed on the last occasion. Initially, my lord, I have challenged the order of review. Subsequently, by filing the application for amendment, I have challenged the original order. But they are supposed to file the opposition and not yet filed. Whether
I'll not use any opposition, my lord.
and in that event, your Lordship kindly allow the amendment application and direct me, my lord, give me liberty to file amended writ petition, my lord.
I just object to
Not required, Mr. Water.
yes, my lord.
It
This
is
is
not
my
required.
prayer.
Your Lordship kindly allow this application for amendment. There may be one difficulty, but there are some annexes, my lord, which is not legible.
In the writ petition, you did not assail the parent order.
Parent order. And your Lordship gave me liberty, my lord, to file the amendment application.
My lord, I just request your lordship, my lord, because this is my 59th year of my lord service. My lord, because of the pendency of this writ petition, my lord, any of my documents of my post-retirement benefits are not being processed. So I just beseech you. So this is why, this is the reason for which, my lord, I have been instructed by my client that she does not wish to, my lord, we file any opposition application so that they would just get a further time for reply.
Have you checked up the application?
Yes.
There is no fresh incorporation of facts.
No.
So we can allow the amendment and take up the matter.
Yes, my lord. Kindly do that. and it takes up this matters, my lord. This is my request.
Can 1 of 2020.
But I appear for the writ petitioners in this matter. It is a public interest litigation where the brick fields allegation
What
was there.
happened to you? Why didn't you appear yesterday?
I was not here. I was not here. She knows the plight of a lawyer.
My lord, so far as my lord, we have filed
Let me, my lord. I know, my lord. Lordship, other day, Lordship was of the view that since it is a very validly operated permit, why have you filed the writ petition? It is absolutely a concocted and false affidavit filed before your Lordship in order to establish an illegal operation of the brick field. establish and to give a
Take us to
lawful
the-
shape to an illegal operation of the brick
Alright,
field.
take us to the facts.
Kindly, my lord,
have used
we
the
made an allegation.
reply you have used.
No, not yet. Lordship did not direct me to file a reply. That they have given, my lord, a report saying that this is a validly operated brick field. But what are the requirements in operation of a brick field? First of all, the
wait, sir. Oh. সকালবেলায় ঝাঁপিয়ে
Environment.
who is appearing for 10 and 11?
My lord, I am appearing for the private.
Yes, Mr. Hotel. Please.
My allegations were in the annexure to Lordship's petition. With the villagers had come up before your Lordship's court, my lord, with a prayer that their representation at page 33 to the district magistrate.
Have
To
you
that-
given the report?
Yes, my lord.
He has given it.
Already served, my lord.
We have given
The
it.
last occasion. it
We
was
have
served.
got two things. One is the alleged report of the authority, and second, a affidavit in opposition of the respondent. Both are my lord, singing in the same tune. Both are, my lord, jointly filing it. Identical documents. What documents are required for the purpose of, my lord, establishment of a brick field? First of all, the land should be shown as a land to be used for non-agricultural purpose. I have annexed the Korchas, Balat, Khutians, that these are the agricultural lands. They have not, my lord, addressed the said issue. No document has been annexed to a Lordship's petition to show in their affidavit that it has been already converted, first of all. Secondly, my lord, this pollution certificate has been given of 2017. I do not know how far in 2026, my lord, the said certificate is valid. Thirdly, my lord, in the affidavit, it will appear, my lord, the royalty has been allegedly paid. My lord, royalty payment, my lord, is dependent on the quantum of earth to be extracted for the purpose of brick manufacturing business. Lordship knows that. That must be a minor minerals. Under the minor minerals rules, my lord, extraction of earth is to be then done, and thereafter, my lord, it will be assessed according to the extraction. They have given a receipt about the payment of, my lord, alleged royalty, a printed form. This amount is paid. At the bottom, my lord, there is a column, royalty, and other cess. So far as the quantum of earth is concerned, they have themselves privately, my lord, has given a document showing that one person has given of their farm
First come to, it is situated according to you in,
on agricultural lands.
come to your representation. Your allegation is it is running without valid permission and without pollution control board certificate, and it is adjacent to a school, and due to such running.
No,
the
paragraph 4, agricultural land.
Paragraph 4.
Set up and running on the agricultural land, which is recorded
Which
as
is the
house.
land, which is house, amon, etc.
Yes.
So you paragraph 1, you have given some 20 or 30 plot numbers.
Yes. Yes. All those land plots are valid.
They show us from page 18, the record of right which you have annexed, that these lands are, what is the classification of this land?
All lands are classified, my lord. At the top lot, you will get a left-hand side.
Agriculture.
Sreni Aush. Left-hand side top. In the Porcha, my lord. In the
Page
record.
18, page 18.
Page 18 itself. Left-hand side top.
House, yes.
This is the classification of the land.
So the, here are about 10 plots records you have given.
Some of the plots are Porcha you have given. Some of the plots Porcha you did not give, my lord, because we expected that the hearing will be conducted by the district magistrate, where I shall give all the documents and records. So other documents also speak of, they have not, my lord, produced any document to show that this property has been converted to non-agricultural land.
All right. This is your document.
Secondly, my lord, in the opposition, kindly take up their opposition.
Yes.
Opposition, my lord, page 12. This is, they say, to be a document for operation of the brick manufacturing business. No quarry permit is there. This is a trade license given by
Acha,
Panchayat.
go slow na. Tell us page 12, what you are showing.
That is Form 11.
Under which act?
On the Panchayat Act, trade license.
Very good.
Trade license, my lord, does not permit operation of the brick manufacturing business. My lord, secondly, my lord, kindly come. This pollution certificate at page 13 is of 2017. It remains valid for, my lord, only season to season.
2017.
Yes. Now no further document has been annexed.
Here the plot numbers have been restricted to
These
plots 270, 2701 and others. Yes, all right. Then,
next, my lord, kindly come, my lord, at page 19.
now what is page 15? This is of 2022.
But this is the environmental certificate, part of the environmental certificate continues up to page 18.
So year to year they have taken extension.
But this is just 2017 document. All are 17 document.
Page 15 is 22 document. It is page 15 is of 16 December 22.
Yes, 16 December 2022.
Very good. Now,
Initial document they have shown of 2017 at page 17.
now page 19 is the
Page 19. Kindly come to page 19, my lord. That is the alleged payment of the
royalty.
royalty or revenue against operation of the brick field. I should say revenue, not the royalty, because no quarry permit is annexed to a lordship's petition, and no royalty can, no manufacturing business can operate on agricultural land. Page 19. Payment is 14,000, 1,47,500. The breakup is given in the next page. Land Reforms and Refugee Rehabilitation Department has given this.
Yes.
At the bottom, my lord, there is a breakup. Collection of royalty from mines and minerals, 1,24,500. And others. But has it at all mentioned anywhere here what is the quantum of brick earth against which the royalty is demanded? Well, royalty is always demanded against the quantum of brick earth. That should be the breakup. This is the quantum of brick earth you have extracted. Therefore, royalty at the rate of this one, I am just claiming. What the breakup they have done? They have given a letter at page 23. Quantum of earth. From the desk of the Hawk Enterprise. Well, am I on 23?
Page 20.
23. I am raising an issue. The quantum of earth is not before your lordship ballot to assess the royalty. This is a privately ballot given document from the desk of Hawk Enterprise. He has said that I have lifted 31,000 CFT of brick earth.
Yes.
This is a lifting certificate, ash lifting certificate. Whatever ash, I don't know, my lord, what they are doing with the ash or with the earth. But I knew as a brick field, into ash, my lord, document has been given. Therefore, my lord, my first submission to your lordship is this: that no conversion certificate was done, which is the fundamental primary prerequisite for purpose of getting a quarry permit for operation of the brick field. The entire village is getting polluted because of this illegal operation of the brick field. The villagers are before your lordship. They say that it's an agricultural land. How can you convert it overnight by manufacturing bricks over the same land by extraction of earth?
Whether it is a bias, they are using a bias.
Fly ash. So what? These fly ash,
My lord, fly ash comes from a thermal power project. So in order to manufacture bricks, they require clay, they require fly ash. I have given the fly ash lifting certificate. And as regards to lifting of clay for Minor Minerals Act, my submission is as per
1 minute, one by one. So there is no question of excavation of any earth.
my lord, clay is required to make brick. I
Huh?
candidly submit that. For fly ash bricks, fly ash is required. But that to the minimum amount of clay we require, we get from Dokhinpara Moja, not from Hareknagar Moja as alleged by them.
Which paragraph you have stated?
Paragraph 9, page 5 of my affidavit in opposition.
কোথায় বলেছে এই জন্য?
Uh,
হুম, হুম, দলিল।
That means you don't have those documents.
District
Had
level.
you been in
Yes.
possession of those documents, you would have annexed.
My lord, I have documents with regard to royalty which has been paid for.
To answer our query, first is what about the change of classification of land?
দিয়ে দে, সই দিয়ে দিস।
Lord, with regard to change of classification of land, my submission is that we are not even taking land from Horeknagar Moja, rather
Acha,
previously
what report has been filed by the police? Let us see.
সে রিপোর্টে বলেছে। পুলিশ স্টেটের।
Sir.
They are said, my lord, the
Yeah,
passive.
please allow us to go through it.
Yes, yes. Sir, এটা আমাদের কাছে ছিল তো, ছিল আপনাদের কাছে, ওটা আছে।
Matter is. Issue of land class one falls within
হরেকনগর।
This is, my lord, may I suggest, my lord, in every district, in respect of running of brickfield, my lord, there is a district level screening and scrutiny committee, my lord, which after considering every aspect of the issue, the land, pollution certificate, royalty, etc., everything associated with running of brickfield is taken care by the district level screening and scrutiny committee, my lord. So after even pollution control board is there, they will also say, they also send their requisite to that committee. After committee considers everything, consent to operate is being given to the operator. So, my lord, may I say, my lord, it may be sent to district level screening and scrutiny committee. They will go through the documents, my lord. Or otherwise, we can sort a report from the
who
district.
are the members of that committee?
DM generally heads it, my lord, or ADM LR is there, my lord.
Let us have them.
Good DM.
Yes, yes. ঠিক আছে।
Electrician. এটা annex করেছে ওদিকে। Page 20.
Page 34.
That is the Pollution Control Board certificate, my lord, PCB certificate. That got issued in 2022, but it is valid till 17/7/2027.
They will scrutinize.
Yes, yes, my lord, validity is till 27.
আচ্ছা, the present petition in form of a
I am for the petition. Petitioner prays for removal of encroachment from the highway and the Noinjoli controlled by the National Highway Authority. Petitioner made representation, Lordship, earlier occasion, Lordship heard the matter, Lordship directed me to produce the relevant provision. And I have given my section 26 of the Control of National Highway Traffic Act.
Where have you stated in your representation that it is highway?
The government land.
15?
I have kindly see the
15
record of
is-
rights.
Eh?
Kindly see the record of rights. Page 13. The Public Work Department, Bharat Sarkar, the Paka Rasta. On page 14 is the Noinjoli.
Page 14 is the
Noinjoli.
Kotian 876 classification is Paka Rasta.
Paka Rasta.
Then in the next page, why it is given Noyanjali?
Paka Rasta and Noinjoli.
It's same dark.
Road and Noinjoli. Encroachment over road and Noinjoli. Lordship, kindly see my section 26.
What is this you are showing?
Section 26, removal of encroachment, unauthorized occupants. Section 26, subclause 2. The relevant. And who is the appropriate authority? Earlier occasion, I have submitted a notification. A district magistrate is the appropriate authority. The power has been delegated to the district magistrate. Earlier occasion, I have submitted. Okay. Yes. Last page, man, kindly see. Oh, section 26 has been delegated to the district magistrate.
So we are sending it to him.
My lord, for a moment, my lord.
You are for whom?
I am for the private school.
My lord, I am for the state, my lord. Before my lord, we have instructions in this matter, my lord.
Yes.
Now, my lord, until and unless, my lord, PWD, Government of India is made a party, no direction can be issued, my lord, in this matter. No, my lord. Only state is the party, my lord. Kindly consider my
District magistrate is the appropriate authority.
In a very casual manner, the retribution is drafted, madam, without implicating the National Highway Authority as a party respondent. Not only the.
My lord, the land belongs to PWD, Government of India, my lord. This is not a state government owned land, my lord.
Assistant engineer PWD has been made part.
State. Assistant engineer.
Now, my lord, may kindly take the page, second page of the report, my lord.
Oh, it was India. Also.
DM is the appropriate authority. DM, I made a party to the district magistrate.
Indian is CPW. CPWD. State is PWD, they are CPWD, most of it. Central Public Works Department.
Neither in the repetition, not in the representation, they are not made party.
No, say the act delegates the
District
power
magistrate.
to the DM.
As the National Highway.
As per this.
National Highway.
We will record that.
No, my lord.
That he will determine.
Yes.
If it is not national highway, DM will not be the appropriate authority.
Yes.
My lord, the report says, my lord, kindly takes the last line, first page, my lord.
Where is your?
My lord,
Two copies given.
I have given two, my lord.
Yes,
My lord, paragraph 4, my lord. As per BLN LRO report, the said plots such and such classification Noinjuli and 407 classification Paka Rasta are recorded in the Public Works Department, Government of India.
Hmm.
So, my lord, Public Works Department, Government of India has to be made a party. Otherwise, my lord, no direction can be issued, my lord. It is with,
No, it has to be made a party. They, but we will direct the DM
my lord,
to hear the representative of CPWD.
my lord.
What is the problem?
No.
The non-implement of CPWD as the owner of the land. Allegation is that is being encroached upon. These are factual issues are involved.
My lord, DM is the empowered in the as per national highway.
No, as
National
per
highway.
this control of,
The control of the national highway.
yes, that
My
act.
lord, that act, not the CPWD act. My lord.
No, Central Public Works Department, that is under the Ministry of Public Works Department, Government of India.
My lord, but in the
This is
notification.
Control of National Highways, Land and Traffic Act.
Yeah.
So in that section 21 provides a power for delegation to the DM. And DM, while taking the decision, will hear you and call necessary information from the concerned department.
That is true, my lord. I'm not disputing that.
Then why you are worried?
No, I'm not worried. My lord, the petition made before this honorable court is a public interest litigation in a very casual manner, my lord.
Pardon?
Very casual manner without implementing the necessary party. Not only that, my lord, the representation made.
But technical approach in
I'm not
public inter litigation is not expected.
This is they prepared a public interest litigation without implementing the
present-
necessary party.
We
My
are
lord,
sending.
Not only
may I
that,
take my lord's leave, my lord, for a moment?
not only that, my lord.
Is your report? Where is you have given your report?
Yes, my lord.
For that.
Both the copies, my lord, I have submitted.
My lord, for a moment, my lord, kindly come to the report submitted by the state authority, national highway authority. The second page, my lord. Second page. Second paragraph, my lord. Construction. This is temporary structure. My lord, got it, right? Temporary. The structure is purely temporary with bamboos and plastic, etc., for the purpose of Ratha Jatra. My lord.
For that, sir, you have to take a permission from the authority.
No, that is not.
If that is there, then it's okay because section
Kindly mention it. The structure
section
is a temporary.
24.
Structure is a temporary structure. It's removed
To
from the.
remove,
Yes.
If there is no permission for that temporary structure, then it has to be removed.
My lord, obvious. I have no doubt about that.
37. So kindly possible.
দেখি না কি
My lord, it is a very simple, my lord, case, my lord.
simple.
Case is very simple case. What is my case? I registered a complaint FIR before the, my lord, Shagodigi police station, alleging that the accused persons, they are the land mafia of the my lord, area. They, by virtue of 5 forged deed, they tried to procure my land. And not
Yeah.
only my case,
2 minutes. Let us go through the order. 25th September order, na?
my lord,
Challenging 25th September.
my lord.
The complaint. Your deeds have also.
Yes, my original deeds.
আচ্ছা আচ্ছা
Yes, my lord. Yes, 93, my lord, government report. Bottom portion.
So you get it back from the court.
No, my lord, my respectful submission in the, my lord, is a big land, but particular my land is 53 decimals, which was purchased, and my lord, BLRO, after verifying the deeds, recorded my names. My lord, in respect of my deed, my owner, no civil suit is pending. But
Which is your plot?
my lord, my plot is, my lord, I have annexed 72, my lord, LR plot number 139. Page 72 LR records.
72.
Yes. Abu Tahir Sheikh 139, my lord, recorded, my lord, 26.26. Come to government report. The IO itself says,
94.
IO itself says that I asked for certified copy from the page 93 bottom portion during investigation, and thereafter IO consulted the available PS records and come to learn that the shoot is such and such is pending regarding deed number such and such, such and such. Then he also found Sagordigi PS number such and such, two cases.
So your contention is your land is not involved in those
Yes,
cases.
not involved.
That's
Other
very good.
lands.
Then the IO has asked for a certified copy of your deed.
Yes, yes, IO asked for.
So you have given the certified copy.
IO, then kindly come
Mr.
to.
Chattopadhyay, your grievance is
Have given.
so certified copy, original is with you.
No, my original was what is the procedure? Government order is says, if I challenge anybody's deed, then my lord, the investigating authority will send will ask report from the registering authority. I have annexed the government order also. The registering authority will certify that the deed I produce the 5 deeds, false deed executed by the
What is your grievance, sir?
grievance against the malad IO, that is malad complaint to the SP, page 85. Page
Yes,
85.
where is that document? They will obtain certification.
Yeah, that has
But
not.
Mr. Chattopadhyay, they have taken your certified copy. That does not mean that you are without your title records. If at all you want the certified copy back on the ground as you have stated, for that you have to make a petition before the concerned court.
No, this is not my case, my lord.
Then
This is
what
not.
is your case?
Whether
My
you are
case is,
you are the complainant,
I am the complainant.
you are the complainant.
I am the
So
complainant.
according to you, your deed, original deed has not been collected by the IO.
No, my lord, IO collected my deed. The forged deed that is lying with the accused person has not been seized. That is why they got bail. My lord, page 85, I made page 85, I made a specific complaint to the SP.
So the procedure is that despite seizure, despite non-seizure of any material document,
My lord,
if police concludes any investigation and submit charge sheet, then what is the remedy?
no, till date charge sheet has not been filed.
Yes. So you wait for
Yes.
filing of the charge sheet first. Even if you finds that the investigation has not conducted properly, then your remedy is old CRPC 173 clause 8 to approach the CGM concerned seeking a direction for further investigation.
That is Naraji reason
Okay.
that I can do.
So why you have come here?
Yes. Why I come here? My lord, kindly come
And
to page
how
85.
you can approach?
Page 85.
You
Page
have
85.
an alternative remedy.
My lord, page
Don't
85.
think that criminal procedure
Your
court has
lordship's
not
answer is,
address the issue.
your lordship answer is 85 and prayer B. I allege the IO is make himself partisan with the accused persons. My lord, he did not take any step for making any seizures.
In
That
that
is,
circumstances, your remedy is not to file writ petition, but to approach the CGM
but
concerned.
when the IO is not acting properly, page 85, I wrote to the my lord
That
SP.
Mr. Chattopadhyay cannot be gone into by us. Try to understand.
My
But
scope
what
is
are you
limited,
asking?
I know. My scope is
Your
limited.
prayer- No, what is your prayer in the writ petition?
Prayer B, my lord. Yes, my lord, 48, 49. Prayer B only.
Your prayer is that you are complaining that without
seizing these deeds.
special respondents to inquire into the matter and to take pivotal steps in accordance with by seizing the false deeds of Sadhana. So
Prayer B.
there is a dereliction on the part of the inspector. Instead of collecting those deeds, they have taken the certificate copy from you. Investigation is still continuing.
Yes.
Try to ascertain what my brother is saying. Now, if you find that upon investigation, the report has been filed without considering the fake deeds as alleged, then the entire investigation goes. And remedy upon you is to file a Naraji petition to that is in future.
That is in future.
Investigation is not. Now, so far at this stage, how the read code said that if there is any threat perception, you give protection to the people. That this read code is.
My lord, the prayer B, my lord, I made a complaint against the IO.
You are wanting change of the investigating officer now. That also we don't have the jurisdiction to
In
decide.
that circumstances also you have to approach the CGM. When investigation is going on, the one court of CGM is in sessions of the matter, then interference in such criminal matters frequently by
we will
adverse court.
We will treat it as dismissed as withdrawn with liberty to you to approach the competent tribunal. Finished.
Only yes, my lord, I know my scope is, but the my lord,
জানোই যখন আর কেন অসুবিধা হলো, এসো।
my lord, report of the IO says that he asked for my lord, report of the IO 94. He says that the my lord, I asked the such and such deed are lying before the court or not, but no report received till late from the collector status report such and such. He asked
Chattopadhyay, you can ask before the CGM by filing an application for further investigation. And even through criminal process. And even you can approach the High Court under 227 seeking re-investigation of any case.
সব জানে।
That the
My lord,
investigation
vast
has not been.
experience regarding my lord trial. I do not have that vast of experience regarding trial. My lord,
I do not
my
also
lord,
have. That is why I am keeping quiet.
yes, both. But my lord,
My lord is an expert.
yes,
Yes.
I know him, my lord.
We got the occasion to deal with.
Withdraw করে নাও।
Then my lord, then my lord, I am my lord.
We
Then
will
my lord,
record on your prayer the petition we are dismissing and withdrawn with liberty to you to take appropriate steps before the competent forum. If আসো, Mr. Chot.
it is pleasure to appear before your lordship
Yes.
also.
Thank you.
Praying for not today.
See, no, he has no pleasure to appear before us. He is praying for adjournment. Yes, what happened?
Item number 5. Item number 5.
Yes, what you are,
Praying for not today because my senior will appear in person in
who
this
is
matter.
your senior?
Alan Felix.
Oh, that
It is his personal matter.
Oh, তাহলে কি করব? What do you want?
Praying for not today.
Not today হবে না। List it on.
And I'm appearing for the respondent number 1. My lord would kindly grant me some audience before the matter is taken up on merits.
No, what
And-
happened
no.
to that matter?
My lord, that matter
That's
is still
26th
pending,
of
my
August.
lord. The next date fixed is 26th of August.
Chalo. We will take it up on 28th August.
My lord,
The order, my lord, last
Anyway.
order in the
my lord, anyway, my lord.
28th August.
My lord, whatever has fallen from your lord, my lord, it's okay, my lord. Only thing is that, my lord, even on the last occasion, my lord, I most humbly pointed out that at the end of the day, my lord, this matter will lose its force. Why? Because, my lord, I have challenged an order by which the learned single judge has given a blanket protection to the respondent number 1 by directing the authority not to take any coercive action against him. In the meantime, my lord, definitely he is complying with that order. Though, my lord, at the time of grant of the order, the primary issues were not considered by the learned single judge. That is the
So,
principal
Mr.
grievance.
Jana, if that issue is not answered, your case also becomes weak, na?
That is true, but my lord, now,
সব জানে ও বাবু।
my lord, now, my lord, ultimately, my lord, this will frustrate the whole issue.
No, why? What had been the court's direction in the special bench that they are finally hearing the matter?
No, it has not been heard. That is why my lord pleasure was to observe on the last occasion also. If that matter is not taken up on that day, fine, we can proceed with this matter.
But Mr. Jana, during pendency of that, can
Yes,
we take
that
it
is
up?
also standing in the way.
You at least will not want us to pass an unimplementable order.
That I cannot.
28th August. Yes, next.
Item number 7, my lord, I am appealing for the appellate.
ওরে বাবা, এটা যুদ্ধ করবে।
My lord,
What happened in that matter? Transfer matter?
transfer matter, my lord, transfer has not been given. Another hearing to the my lord, Director General has
Yes,
been
tell us what
ordered.
is this matter?
My lord, this is my affidavit of circular. First, let me tell your lordship that there is a delay of around 390 days, my lord.
তো অল্প দিন। Very few
No,
days.
my lord, reason of the delay is very, my lord,
Where
it's
is
a-
the
it's-
order
the-
dispute?
kindly see the order, my lord. Murder of the son of the
Yeah,
appellant is
give us 2 minutes time.
my lord.
Yes, what is the wrong, sir?
My lord, the investigation
But
2000
the writ petitioner appellant.
writ petition and appellant.
Uh,
My lord, the investigation is not going on properly. 2018, my lord, my son was murdered. The private respondent number 6 is the contract killer. Respondent number 7 is the daughter-in-law of the accused, of the appellant. My lord, after 14 months from the date of the murder, my lord, the lady was arrested. Within 3 months, she got her bail. Now, for 8 years or so, or even more, my lord, the investigation is not, my lord, completed. Kindly see the order of the learned trial judge. What has been stated? The forensic report has not been placed. 8 years ago, my lord, the documents, pen drives, hard disks of our, my lord, computer, everything have been, my lord, seized by the police authorities. The seizure list is here. The forensic report is awaiting. Now, my lord, why the daughter-in-law of the appellant came in contact with the contract killer, my lord, that has not been traced out by the police authorities. We say there is an interstate sex racket, and the lady, the private respondent number 7, is a part of it. My son, my lord, the deceased son, my lord, he downloaded in her entire, my lord, chat history of all her social media and, my lord, WhatsApp chats also. These are, we have not done this.
So
He
why
did
you
it.
are telling this to us, Mr. Chakraborty?
Yes.
Why you are telling this to us, Mr. Chakraborty?
Roy.
Roy, oh, acha. Sorry, yes, Roy.
No, my lord, this is the subject matter. This is the reason. No, my lord. Kindly see the seizure list. I'm sorry, charge sheet.
You tell us what is the wrong in the
Wrong, my lord. We wanted CID or CBI investigation in this case. For 8 years, my lord, we are running after the police authorities that, see, there are some evidences. We have
the stage of the proceedings before the trial court.
my lord, the trial has not commenced. These
Charges have been framed, additional charge sheet has been filed, supplementary charge sheet.
supplementary charges has been filed, my lord, additional charges. But the, my lord, the custodial interrogation of the
So
main
there has
accused,
been no final report, investigation
there is nothing.
the trial is alive.
Trial is alive, but my lord,
So
so
what
far,
help do you want?
kindly see, my lord, the
Change of the investigation authority at this stage may not be warranted because it has progressed substantively. So on that basis, police, you filed a Naraji,
Please,
which
Millard,
accepted.
Millard, today, right now, Millard, there is a change in the administration, Millard. I'm not on that, Millard. There is a change in the administration for 8 years, Millard. The Millard, earlier administration did not pay any
Pray
heed to what
something-
we say.
You pray something from us which can be given.
We
We
are
don't
praying,
have
Millard.
anything to give.
Kindly see the agony of a mother, Millard, who lost her son 8 years ago. She is running after police authorities, courts, everywhere. But, Millard, why the son has
You are
been
saying that your Naraji petition was accepted.
my Naraji petition was accepted, that was allowed, Millard.
That is the
Kindly see
procedure
the
of law.
then, Millard.
Acha, can we take up the investigation and
I am not on that, Millard.
Then
I am not
what
on.
you are on?
Kindly see that two, Millard. First of all, the report that was filed by the earlier Millard advocate appearing for the state
Then
is
you
not with
file
me
your
right now.
opposition to section 5. Matter will remain pending. No purpose will be served with that. Try to appreciate.
At least, Millard, let police authorities take some proactive role.
That has
Kindly,
been noted by the court.
that kindly
Court
see.
says that I am happy that in spite of ceasing of this writ petition, they have proceeded with the investigation.
They are proceeding, but Millard, the main reason why son was killed, Millard, for 8 years, I am yet to know. For 8 years, Millard, I am
petition, madam, sir, we cannot pass any order in this.
kindly, Millard, what I pray before your lordship, Millard, kindly see, kindly consider one thing.
Now, one thing, your contention is that some documents, say the cyber forensic and digital,
Those are not documents,
have
Millard.
not
Pen
been
drives and
collected.
hard disks
Have not been collected.
have been collected. They have not been
Okay,
examined
the
by the forensic authorities.
Investigating officer has pointed out that the said report would be submitted in due course before the jurisdiction.
But that has been done again. The supplementary charge sheet we have already filed on the 30th of June.
Supplementary charge sheet, Millard, is the replica of the first charge sheet. Kindly see, I have annexed
More
both.
than one.
There is no change.
Supplementary charge sheet can be filed. And
Have been filed.
even after commencement of the trial, one person can be brought, can be in the array of the accused person.
Millard, at least
319 CRPC.
At least, Millard, some reason why the son was killed and why the daughter-in-law, rather the wife of the deceased, came in contact with the contract killer. Those are yet, Millard, to be revealed. Kindly see both the charge sheets. First charge sheet is at page 12 and the supplementary charge sheet is at page 83. Both are identical. There is no change. And Millard, so far as the second investigation of further,
supplementary charge sheet.
Millard,
Additional 2% has been implicated at
no,
as
kindly
accused.
see page 83. Millard, Mohammad Mazhar and Papia Mondol.
Who is for the private respondent?
Private respondent is not appearing there. They have not appeared before the single bench.
I understand my learned friend, but by pointing out at page 83 is referring to the first charge sheet.
No, this is
Because
second.
the second charge sheet, my lord, I understand, my lord, cannot annex because it was not a part of the writ petition.
No, it was not. It was not. It was filed by them before the writ court. Kindly see page 84, Millard, date 31st January 2025.
My lord, I am referring to the charge sheet dated 30th of June 2026. The submission of the state was also recorded, my lord.
Kindly see the charge sheet, Millard. Date of the charge sheet 31st January 2025. And Millard, page 12 is the
Where
first
you are
charge.
where you are getting
Page 84.
Yes.
FIR number 196 of 2018.
Yes.
Dated 24th November 2018.
Charge sheet is 31st January
2025.
Yes.
Then Millard, now Millard, kindly see page 12. That is the first charge sheet. 23rd January 2022. This is the first charge sheet. FIR number is same, lodging of FIR date is same. 23rd January 2022. And my lord, this.
Sir, wait, give us 2 minutes time to go through it. এটা কি ফাইনাল রিপোর্ট না চার্জশিট?
চার্জশিট, হ্যাঁ।
তাহলে সেকেন্ড চার্জশিট আবার কি করে?
ওটা সাপ্লিমেন্টারি।
বলছে 2026 এর একটা হচ্ছে। What has happened?
My lord, we have filed, my lord, as has been recorded, my lord, in the order of the Honorable Single Judge, that report is awaited as far as the Cyber Forensic and Digital Evidence Examiners Laboratory (CID) is concerned. The investigating officer has pointed out that the said report would be submitted in due
No,
course
Mr.
before the.
Bhattacharya, the page 12 is one charge sheet of 23rd January.
Yes,
And page 89 is another,
yes,
After 3 years.
is another charge sheet of
Yes.
31st January 25.
yes. Thereafter, my lord, the third supplementary charge sheet, we have filed it on 30th of June
This
2026.
is not with me. They should give a copy, my lord.
Then you go on talking, sir.
My lord, I was humbly beseeching my lords, my lord.
Just on, let us.
Yes, yes.
Sheet খুবই deficient হয় তাহলে।
It is pending before the Cyber Forensics Department and it will be filed very soon. My lord, kindly takes, my lord.
Further report is awaited.
Yes, yes, yes.
Also, is pointed out that the schedule is submitted in due course before the jurisdiction.
Yes, that we have submitted, my
And
lord.
seeing that, you have filed that
Yes, the
supplementary charge.
yes, the second supplementary charge sheet on the 30th of June 2026.
No, then this will be the, yes,
Third.
second supplement.
Second supplementary charge sheet, my lord.
Do you have a copy of that?
No, right now I don't have. My client also don't have a copy. My lord, nothing has been served yet. As so far as my instruction.
Get it from the court.
I will. This one also, my lord, I have applied for the certified copy, the supplementary charges in and I got it.
2%, namely Mohammed
Mazhar,
Nazar and Papia Mondal have been cited as accused person.
in the first searches also they too are my lord, made parties.
In the first one, it was only one.
No, 2. Page
Two.
13. Page 13, 1-3.
Okay.
Yes.
Now you
Mohammed
come to
Nazar.
page 84.
84, the same name, my lord, no new name has been recorded.
84 property description. You come.
Mohammed Mazhar,
লাল কালো রঙের পেন ড্রাইভ।
Yes, this is, my lord, what has been stated in the first search sheet. Pen drive, hard disk, one revolver.
Further document, digital evidence, that would be also produced by
Identical.
filing supplementary
Both the charge sheets are, my lord, identical. There is no change.
It was picked on, my lord, 22nd of June 2026. But for consideration of charge, but there was a resolution adopted by the local bar. The next date is, my lord, now the matter was adjourned.
This is going on for 8
This
days.
is
So
very
you will
difficult.
not allow anybody else to speak. Very difficult to hear.
That means case has been committed. Now that date has been fixed to consider for charge of the charge. Now charge shall be framed against 2 accused persons. Now it is your thinking that these 2 persons engage certain contact killers. let this evidence
No,
come.
Mazhar is the contract killer. No, Mazhar is the contract killer. That is evident from the police report.
Who is the mother?
The accused number 1 in the charge sheet. Police says he is the contract
Petitioner.
petitioner. Here is the mother of the deceased.
Then which mother are you
No,
speaking?
that is Mazhar.
Mazhar.
Mazhar, Mohammad Mazhar.
Mazhar had an illicit, that is what the charge sheet and the report says, an illicit relationship with the wife of the victim. So the victim got to know about the relationship from social media and phone calls, etc. Now they
161 statement of the Millard of the wife of the victim. Millard, kindly see.
When
She
is
is
the
saying.
next date fixed?
but the next date is fixed before the learned trial court on the 5th of September. And may I file the report, madam?
Let a copy.
Report, well, it's the ongoing investigation. He has access to the charge sheet.
I am the Millard de facto complainant. I must get a copy.
De facto company appoint one advocate who will assist the PP. Okay, and if any evidence comes that
There is an advocate, Millard.
any other accused person are involved, then you will file an application 319 CRPC.
At least from these two Millard charge sheets, no further nobody has been appointed, rather named as accused. These two names are Millard standing. In the series of letters written by the mother of the victim, Millard, page 33 to 40 for CID investigation.
The recovery under section 27 evidence act. It was recovery in consequence of information obtained from the accused person. Recovery of firearms.
Yes.
Now evidence according to your perception is required.
And Millard, we are not aware about the further investigation also. Police must apprise us that the further investigation is going on. You must come attend.
If this is, my lord, the submission or the stand, my lord, but may I just indicate, my lord, the issue pertaining to, my lord, whether an appeal is maintainable, my lord, arising from a criminal writ petition, that is pending before the larger bench.
It's a
That is,
WPA. It's a
that is pending. Just a second, sir.
It's
That
a
is
writ
pending before
petition.
the larger bench, my lord. This issue, the matter is still being heard, my lord. Whether in view of Ramkishan Fauji's ratio.
Mr. Bhattacharya, don't be so harsh.
No, since my learned friend is, I'm trying to help him out.
I also.
What I was, had he known all this, he wouldn't have preferred an appeal.
Millard, police is not doing anything. That's why I'm
May I
before
just-
this honorable court. That let police
But an aggrieved mother is before the honorable court, my lord. There is an application seeking condolation of delay. I will not be hyper technical, my lord. I understand, my lord, the pain, my lord, of the mother who has lost her son. But before the honorable single judge in the writ petition, it was only, my lord, the first charge sheet which was on record. There was no challenge, my lord, to the second charge sheet, and my lord, there could not have been any challenge to the charge sheet which has been filed on the 30th of June 2026. But the law, as it says, my lord, that in exceptional cases, my lord, as propounded, my lord, in the Best Bakery case, the Honorable Constitutional Court has powers to direct, my lord, investigation, re-investigation, further investigation. So, my lord, the disposal of the writ petition, the order whereof has been assailed before your lordships, that will not stand in the way for the petitioner to file a fresh petition assailing the entire conduct. If that liberty is granted to him, he
What
can.
liberty? What liberty?
That this will, the disposal of the writ petition by the honorable single judge will not deter the writ petitioner from challenging the conduct or challenging or praying for a.
He wants an early disposal of the trial. This is his agony speaking.
He's
He's
praying for, my lord,
agonized. He's
by, my lord, the
agonized.
CID, my lord. That is his prayer in the writ petition.
Ashok,
I still can
represent-
believe in West Bengal police, my lord, if they do it properly.
It has been
It's
done.
not that
We
I-
say
I
it has been
still
done.
can believe in West Bengal police, my lord, if they can do it properly. For 8 years, nothing has been done, my
No,
lord.
we say it has been done. Everything has been.
Third charge sheet, my lord, is not neither before my lords, not before me. I have not seen it. They should have brought it. I'm grateful. চন্দ্রোদয় রায়।
বই আমাকে দিয়ে দিয়ে কারেকশনের জন্য।
I am for this thing.
I'm appearing for the Public Service Commission.
Item number 8,
This is a review.
review. আর কি আর পৌঁছাবো আমরা?
A review I have filed. I'll arguing whatever points I have not for mostly for the reasons that this is the last chance the lady had because of her present age. He cannot participate in any other selection process. So she is taking the last chance before this court also. I'm glad.
What is the error in our order, Mr. Ahmed?
Difficult to find blood. If you kindly state when blood takes up page 5 of the order blood.
Page 5 of the order.
There was illegality in the selection process. Lordship has decided that after participation, you cannot take that point. That is the, as far as but I have understood that that's the common substance of the order. But page 5, I was trying to find out error from the orders.
Yes, page 5.
Page 5. Now, the second paragraph, indisputably, petitioner participated in the selection process, being well aware of the terms and conditions of the advertisement. It is not a case that only upon participating in the selection process, the candidate came to learn about the illegality or infirmity in the selection process. The petitioner admittedly did not challenge the advertisement or any of the clauses incorporated in the same. This is first part of the order. What was the illegality? Illegality was the entire selection process. Admittedly, I am a better qualified candidate. So far, excluding interview. Interview, I have obtained 60. The candidate who has been secured appointment has obtained 65. What they have done, they did not take into consideration the written test. Aggregate, they did not consider. Only the interview, they have based the selection. That's the illegality. That they cannot do. That Supreme Court I have cited. Now, the second part, even if I assume that this first part is settled principle, that after participating I cannot challenge it. Then the next part of it is the last candidate recommended is court has recorded this. Now, so far this part is concerned, the petitioner admittedly did not challenge the advertisement or any of the clauses incorporated in the same. So far this part is concerned that court has recorded the advertisement at page 4. My only submission is
page 4 of
the order. 4 of the order. Which the court did not consider according to me.
What did not consider?
Page 4.
Did not challenge the advertisement.
No, I did not challenge the advertisement.
Or any of the clauses incorporated.
Yes. So as if the whatever is there in the advertisement, I have to accept that. But my submission is that court has quoted the advertisement in the page 4, second last paragraph.
Yes.
It starts that in that advertisement number 10, 2019, it was inter alia stated as follows. Now, the second paragraph, commission may fix qualifying cutoff marks of all the categories of the vacancies in each level of the examination, written, interview and aggregate. Now, my submission is, therefore, they have to give meaning of the word aggregate. This was not, in my understanding, not considered
No,
by the.
we didn't follow. You
Let-
can set cutoff for written interview and aggregate.
Aggregate.
What is your contention?
My contention is that
No written marks were taken into consideration, only interview.
interview.
That was your primary submission.
That is my submission. And if they consider aggregate, then I'll be one of the qualified candidate, having better marks in the written examination.
No, their contention was we took into consideration the written marks to
Sort
create
out the
this zone of
candidates.
interview,
Yes.
shortlist the candidate.
Shortlisting the candidates.
So
I don't mind that they have done, fixing certain cutoff box.
then what is the error, Mr. Shah?
Error is, then what is the meaning of this aggregate? How they have considered this word aggregate that they have incorporated in the advertisement.
No, that starts with the sentence starts may fix qualifying cutoff.
Yes.
There is no mandate upon the
If it is-
PSC that you have to create an aggregate.
This may, with all due respect,
তো বলো আর কি করবো বলো? What
না, ওরা কিভাবে করেছে on the
Right. It's difficult to, I understand the difficulties before the court, and page 6 of the order, court has recorded that there are 9 vacancies. Now,
where we have
page 6.
last page of the order.
Yes. Now, nobody has come forward except me to challenge the selection process. Nobody has come forward except me. Whether they can, I don't say sympathetic, mercy, but sympathetically they can consider, since there was vacancies. That much I can say, since the lady does now is deserted lady having a child, has nobody to look after, is doing that private job. If he can last age of his life, can secure one job, that's all. I have nothing more to submit. I do not want to cite judgments because law is well settled.
That panel has been expired. That point I was argued, Lordship.
Yes, that I have challenged within the lifetime of the panel. That we have done. Not that we have, after expiry of the panel, I have approached the court. That is not our case.
Matter number 9.
My lord, I have filed the review application. Yes, my lord, petitioner is challenging the order passed by the learned single judge. Petitioner is not getting the pension and single judge holds that petitioner has not completed the qualifying service. Therefore, the appeal has been papered. And learned advocate of the appellant gave a no objection on 19 January 2024. Thereafter, he has submitted on before your lordships, my lord. The appellant does not face this application without written instruction. My review application, para 456. Learned advocate submitted upon instruction the appellant.
Which order you are seeking review?
Well, 10 November, page 9.
10th November.
Page 9. Review application.
There is
Already-
a delay. You have completed service.
I have completed survey. I have one copy in course of the. I have already served the statement.
Acha, show us the order.
Yes, ma'am. Page 9, ma'am.
10th November.
Yes, ma'am.
Mr. Das learned submission that the appellant does not want to proceed.
Proceed. He has already given no objection. Page 14. Lord, can you come to page 13?
Page 13.
Yes, ma'am. Maybe from there to the. There is no.
Tale, how did he appear?
Yes, my lord.
Page 13.
Yes. Status study.
কোথায় দেখাচ্ছে?
Yes, ma'am. After the in my memo of appeal, my lord.
Memo of appeal, yes.
Yes, ma'am. Memo. Yes, my lord. Memo of appeal, last page. S. Mitro, Vokalatnama filed 19 January 2020.
Page 13.
Memo of appeal, last page.
Memo of appeal
After the order passed by. Status report.
আরে বুঝতে পারছি না তো। হ্যাঁ, after where you are getting 13
status report, second page.
Status report.
Yes, ma'am.
Second page.
Yes, 19 January 2024. Okalatnama has been filed.
এটা কি? Document details.
Document details. The last column.
19th of January 24.
Yes.
সেটা কি?
Okalatnama
Okalatnama file.
Yes. No objection has been filed. They have given no objection. And I have stated in paragraph.
No objection was given on 19 January
2024.
And the order has been passed on
10 November 2025. Learned advocate Tarabodhas given no objection. 2024.
So from 24 till 25 it was unattended.
No. Last
when no objection was given 19 January
24.
Then some advocate.
No, appeal. Previously, appeal has been filed, my lord. Memo of appeal has been filed. Therefore, I have filed the application.
You are challenging the order of 10th November 2005.
And without written
in appeal, your fresh Wakalatnama was there.
In appeal, yes, my lord. I have filed the Wakalatnama and without written instruction. They have submitted.
Acha, so why didn't you appear, sir?
Then I did not have your matters dismissed for default. They have submitted before your lordships, my lord.
তো সেটা তোমার এসে বলো যে why didn't you come?
And my client.
When you are engaged from 19 January, why didn't you appear on 10th November 2025? এক বছর.
My lord.
Tell us what is the merit? What did the writ court say?
Yes.
Show us the writ court order.
The writ court's order in the stay petition, my lord, I have annexed.
Page.
Writ court's order, my lord, I have annexed in the stay petition. At present,
Yes,
I have fixed the
stay petition can one.
Yes,
can one is review.
Yes, can one. This is the review application.
Your service is complete.
I have served upon the state. Yes, the state is the main respondent because petitioner is not getting the pension. Honorable single judge holds that.
Give a copy to Mr. Bhattacharya. দেখি where is the order? দেখি অর্ডারটা বলে দিয়ে দাও। আরে অর্ডারটা where is the writ court order?
Writ court order, my lord. In this review stay petition, I have annexed.
আরে পেজ নাম্বারটা বল।
পেজ নাম্বারটা বল। অর্ডারের পেজ নাম্বার, অর্ডারের পেজ নাম্বার।
I have stated in my petition, my lord.
অর্ডারটা কোথায়?
Order, I have not review petition. I have not annexed. I am challenging the order first on 10 November, my lord. I have stated. Yes, my lord. Para 2 of the
para 2. Why should we read in para 2?
Because honorable single judge. I have not annexed the order because, my lord, I am challenging the order and filed the appeal and stay petition. and they are challenging
Pursuant to your lordship's direction, my lord, on 9th July, my lord, I am filing this supplementary affidavit. Sought for review of your lordship's order dated 29th January 2026. That is in my memo appeal, page 5. In the, my lord, supplementary affidavit, my lord, I am annexed two documents wherein, my lord, the government of West Bengal, my lord.
Yeah, let us go through.
Yes, yes, yes.
এই এদেরকে একটু বলো না এসিটা একটু কম করতে।
Donated 21 bighas of land for construction of school building. At that point of time, there is a rule 1969 management rules. In terms of the rules, my lord, in the formation of
the impugned order in the appeal.
Yes.
Order impugned in the appeal. That is page
page 5 of the
23rd
memo.
November 2016.
29 January 2026 of your lordship's order.
Writ petition order.
Yes, writ petition order, my lord. That is
23rd November 2016.
Yes, 2016. That is not, my lord. 23rd, 12/8/2025. In my stay petition, my lord. Page 8. In my stay application.
Page 8.
Yes. of my stay petition, my lord. Lordship got it?
Yes.
That is the impugned order.
Yes, what is the wrong in order?
Wrong in order, my lord. In rules 1969, there was a provision to as a founder member in the managing committee. Rule 5B specifically, my lord, clears, my lord. In the year 2013, 20th March 2013, government issued a notification for Wheeling School, conversion of Wheeling School from recognized non-government aided school into sponsored institution. The school, accepted the option and converted into sponsored institution in the year 2014. Thereafter, in the year 2015, management committee was constituted. Petitioner name was deleted from the managing committee. Petitioner moved before this Honorable High Court. That is order, my lord, dated. I am annexed in my stay application.
23rd November.
Yes, 23rd November 2016. In terms of that order, my lord, the school authority allowed me to participate in the process in the managing committee. Now, in the year of 25, my lord, again there was the formation of managing committee. I was again deleted. Against the action of the school authority, I moved before.
That was referred to the teacher in charge, to the deputy secretary.
No. That is district inspector of schools recommended our prayer, my lord, before the deputy secretary board.
No, 23rd November 2016,
yes,
each petition was disposed of
with a direction upon the school authority to consider our prayer.
Then what happened?
In terms of that, my lord, your lordship kindly comes, page
21.
Page 21.
This was the decision.
This was the decision taken by the school authority. 20 onwards, 20, 21, 23, I allowed to participate in the managing committee under new rule. Page 21, that was the order sheet from the school authority, the then teacher in charge of the school.
Then what happened?
Then, my lord, again, when the managing committee was, again, my lord, formation for managing committee, I was deleted. Against that, I moved before this Honorable High Court, and that is the impugned order challenge before your lordships, and your lordship passed.
Then deputy secretary.
Yes, that is, my lord, in my supplementary affidavit.
After you challenge, after the new managing committee came, you were ousted.
Yes.
Then you preferred a writ petition.
Yes.
What happened to that writ petition?
In the writ petition dismissed in merit.
Then what was relegated to the deputy secretary to consider?
Deputy secretary relegated to consider our case in the year 2014.
Where do we get that?
That in the supplementary affidavit, my lord. In my supplementary affidavit, your lordship will get it. Page 6 onwards. The most relevant, my lord, the last page, my lord, page 10. Page 10, last paragraph of my supplementary affidavit. That is the relevant.
This was on the basis of a High Court order?
This was on the basis of my prayer.
After you were removed?
After my lord, removed and school was converted into sponsored institution.
This is of 2019,
2014.
14.
Yes, that letter of recommendation before the board to
What did the board say?
the last, the page 10, that is the relevant paragraph.
This was in your favor?
Yes. Page 10, Lordship, kindly. May I read?
May be introduced.
Yes.
Now this was complied with?
No. Deputy Secretary Board still was sitting tight over this recommendation.
Maybe introduced. This is the district inspector.
This is the letter written by the district inspector of schools to the
Then
Deputy
who sent
Secretary
it
Board.
to the board?
Yes.
By which order it was sent to the board?
Yes, Lord.
Now you are seeking review.
Yes.
So what was the wrong in the order?
The wrong, Lord.
Or error in the order?
Yes. Lord, that is the first.
No, this DI order was passed in 2014.
2014.
Then what happened after that?
After that, Lord, I moved before this Honorable High Court in the year 2016.
That is page 18.
That is page 18, 23rd of November, 2016.
23rd November
2016.
Page 18.
Yes.
Yes. Then what happened?
Then
Board directed the teacher in charge to decide.
Teacher in charge decide. Teacher in charge decide to allow me to participate in the managing committee.
How we will know that? That is next page.
That is below page 21, page 20 onwards.
Page 20. Then you were allowed.
Yes.
Now the new managing committee came thereafter.
Yes.
And then this.
I, my lord, participated till 2019. Thereafter, school was run by administrator. In the year 25, I was again ousted.
Then what, 2014, why did the DI, before this 2014 order of the DI, did you prefer any writ petition?
After that, due to no decision was taken by the board, I moved before this Honorable High Court. In the year 2016.
Board will take a decision where it was said.
That is the letter written by the district inspector of schools.
Yeah.
In my supplementary affidavit.
From the board B1. So, all right. So this. So when board was on the basis of this, you continued to function as
managing committee.
But but the board did not take any decision.
Board did not take any decision.
Now who went to Supreme Court?
Lord, I went to Supreme Court before me, Lord, by challenging your Lordship's order dated 29th of January 2026. Supreme Court, my Lord, dismissed the SLP, but liberty was given to file review application before you.
Very good. Now tell us what is the wrong in our order?
My Lord, that 72 rules, my Lord. Now the new rule came, my Lord, after the sponsored institution. In the there was the previously 69 rules. Composition of managing committee, there was a category founder and donor. Rule 5B of 1969 management rules. In the 1970
rules, have you brought the rules?
Yes, I have. Then, my Lord, after 2013, when the school converted into sponsored institution, 72 rules came. In the 72 rules, my Lord,
2013 school became sponsored.
Sponsored.
That notification?
Sponsored. After the
where is that notification?
Yes, in the supplementary affidavit.
Page,
my Lord. That is the general notification, page 4. That is the notification dated 20th March 2013.
Yes.
in terms of that school converted into sponsored institution.
Right.
And the rules 1972
Has
came,
to be
in,
followed.
came into force.
Hmm.
Here is the difference, my lord. Only the nomenclature is changed. Your lordship kindly see the rule 1972.
But the provision towards founder was not there.
Founder was not there, but there is a provision in the rule 5.4, my lord. There is a provision 2% will be included in the managing committee.
Where?
Yes, yes. Interested in education. Your lordship kindly see the rule. Only the nomenclature is changed. There is no founder or donor category. Legislature intention was same. In this rule, my lord, composition of the committee, rule 5,
Yes.
4, Roman 4. Lordship got it?
Hmm.
Roman 4, 2 persons interested in education to be nominated by the director of school education West Bengal. But there is no clarification who will be the interested in education. In the DI letter dated in the year 2014, it is clear that our intention was to cater the education in the society. Accordingly, we are interested. Then why, I am asking myself, why we will not be included in the Roman 4 of clause 5 below? We are the interested in education. That's why my father donated.
New point you are taking. This is a new point you are taking.
Yes,
This
that-
was not there in the read.
Now I am taking this point below. That is correct. I am taking the point before you.
There is no law, rule, nothing.
Rule is there. 2% interested in education to be included in the committee.
2% interested in education and the son of founder or the person who aided the government in setting up the school is totally different.
But
you in the capacity of founder or under founder category, you want to be inducted in the managing committee since your father gifted certain property to the school.
Because
you want.
We were interested.
Under founder category, you want to be included in
That
the
is in the-
managing committee.
Yes, that is in the
Now-
year 69
Now, where
rules.
is the rule? Where is the rule where is the provision in 72 rules?
Yes.
Permitting the managing committee to induct a person under that category.
Yeah, here is specifically the nomenclature is changed. That is true.
Whether
But
nomenclature that
here
is
is a provision that 2% interested in education. But here is no clarification, the person who will be interested. Accordingly, my lord, my humble,
Mr. Mukherjee,
humble prayer before your lordship.
interested in education and founder are two different things.
Yes.
Your argument is that a founder should also be construed as a person interested in education.
Yes.
No, that is not the concept. Concept is why the founder was created. At that time, you donated your land to the school. In appreciation of your act, school used to keep you in the managing committee so that in any policy decision you can say, because it is on your land the school has been built. That was the guarantee given to the founder member at that time, that donate the land, you become the founder.
That was the previous.
Try to understand.
Yes.
Now, today, what are the admitted facts? There is a new rule. It is also admitted fact that you worked for the school, you donated land that has been recognized in the order of the DI. We understand that. On the strength of that, school suo took you as a founder member. Subsequently, when the new managing committee came, new managing committee took the instance of the 72 rules. Issue was whether 72, when you were the 69 rule founder member son, whether you can continue that position in the 72 rules. Now, 72 rules specifically says that this, when the 2013 circular kindly come, page 4.
Yes.
Page 4, this kindly come to rule 5, Roman 5. The rules of management of sponsored shall be extended to the school by formation of new managing committee as per the rules.
Yes.
Now, the new managing committee, which was formed after it became a sponsored, there was no obligation on the part of anybody to take you because your founder member category was
Done. But my lord, here the intention of the legislature to include the persons who are interested in education.
all right. This, Mr. Mukherjee, you are arguing a point. In review is not, we are not sitting in appeal. We are reassessing our judgment. Review is not an appeal. It is a right given, statutory right given to an incumbent. So our main judgment has not been disturbed. Supreme Court SLP dismissed. But review, you yourself, you are saying that this point was not argued in the review.
No, that is
Then,
correct.
Mr. Mukherjee, how can we help you? Tell us.
Lord,
Show us the path we will.
my lord, humble submission before your lordship, my lord.
Your only argument is the nomenclature has been said, stained, but the concept
Concept
because
of the legislature.
founder member is a member interested in education. এইটা তো এখানে কি করে বলবো?
My humble submission before your lordship, if your lordship kindly, my lord, that when the district inspector's recommendation is still pending, lordship kindly let the director of school be directed to consider the recommendation made by the district inspector of schools in the light of the 72 rules 5 Roman 4. Who were the, I am asking us, who are the
Get that
interested?
submission before us in appeal. That submission you made, that when DI has recommended in my favor, let it be considered.
Let it be considered, my lord.
You are now changing your stand.
No, my lord, your lordship knows.
Once
Well, raw point I can argue at any point of it is
No,
your lordship's.
Review you cannot. Subject to correction. Review is not a re-argument of the case. This,
But my lord, when
because you show us the path, we can
no,
follow that.
it is a, my lord,
We understand your because you have fought a lot. 2013 onwards, you had been fighting. You even went up to the Supreme Court. We understand.
Lord, after the promulgation of rule, I participated in the managing committee in the new rule. Now the doctrine of approbate and reprobate, my lord, that is also implied in this case.
No, and
Once you have accepted,
illegality or an irregularity does not create any
Yes, sir.
equity in your favor.
Lord, lordship,
You
my
know
lord,
everything still you are saying.
humble submission before kindly
Humble submission কি করবে?
direct the director of school education to consider the recommendation of the
After
DI.
dismissing your appeal, can we do so? After dismissing it. কি করে করবো?
Then my fate, my lord, I donated the land for need of the society, 21 bighas of land. The person, it is a same, we were interested in education.
The present memorandum of review along with
Praying for short Passover, my lord.
Who is your outside? Who is your senior?
Mr. Nilanjan Pal, he would appear in this matter.
Nilanjan Bhattacharya.
Yes, my lord.
Where is he?
My lord, he's on legs.
Lord, on the last
my lord, I'm
occasion,
praying
he
for-
What is your instruction you have received? Show us the instruction.
This is the affidavit of service, my lord, where, my lord, your lord
File দাও।
directed to serve upon the DL and LRO, my lord, who was subsequently changed. And my lord, your lordship was of the view on the last occasion that if there is
I'm
no
not holding
state,
the instructions, my
then
lord,
they
right
will
now. My
face
lord,
the
I'm praying
Mr.
for
Bhattacharya,
I'm praying for short Passover, my lord. But he's on legs, my lord.
ask him to come immediately.
My lord.
because last occasion, Nilanjan Bhattacharya didn't appear. Another lawyer was deputed to appear.
Nilanjan Bhattacharya is
Nilanjan
the
Bhattacharya,
Initially, your lordship called him in court number 11
my lord, he
to
is
resolve
assisted
the
by
matter.
Mr. Nilanjan Pal, my lord.
Nilanjan Pal.
My lord. Nilanjan
Where
Bhattacharya.
is he?
My lord, he's on legs before courtroom number 18, my lord. That's why I'm praying for
Send him
short.
an intimation, court wants him here.
My lord,
Immediately upon finishing, he must run to this court.
my lord.
Passover, পরেরটা রাখ।
Grateful. Grateful.
14. Yes. Who is for the petitioner? 14. You are for petitioner?
Yes.
Eh? Why you are so slow, Mr. Nondi? Do not want to do the matter.
Affidavit of service, not
Take substance.
your lordship directed me to serve the copy of
করনি স্যার।
Dotto. No, we went to serve the copy to Dotto, my lord. Initially, he refused to accept. Today, my lord, he said, my lord, I could not contact with the such and such. That's why, my lord, I am very accurate.
2 weeks, yes.
Send directly to the respondent.
Initially, I have served upon the petitioner.
Oh,
All right.
None appears,
It,
then
it will appear on 29th. 12th August. Yes. Next. Fileটা দাও। We are not passing any order. We are keeping on 12th. Ask him to take instruction and come back. Yes.
নেই তো। জগদীশ রঞ্জন দাস।
ওই 12th August দিয়ে দিয়ে। Next.
Hmm.
70.
Yes. Lordship, I am for the petitioner who was the applicant before the learned tribunal. And I am partially aggrieved by the order impugned, wherein my prayer has been granted, but it was granted in a manner that I have not getting the appropriate benefit which I ought to get in.
I'm appearing on behalf of Union of India.
Yeah. To
You have annexed. It was upon exchange of affidavits.
yes, madam. Everything is there. And the prayer which I have prayed before the learned tribunal is set out here under at page 10 of my writ petition.
Directed to antedate the appointment of the applicants notionally.
Yes, Mallet.
So you are aggrieved thereby. You want actual benefit.
No, notional Mallet because
the applicants will be entitled to all consider except the difference in wages for the period they have not actually worked as a. This order will be implemented. Then what is the problem?
No, problem is this, Mallet. If your lordship go to the first pair which I am asking for, that is a direction upon the respondent to implement the order dated 22/3/2025 passed by the Honorable Tribunal in OA number 1005 of 1998. So this particular order
That was affirmed with a modification by the High Court.
Yes.
Where is that High Court
No,
order?
so far the modification is concerned, my lord, it is affirmed, but not with the modified.
What the tribe? Show us your prayer 1, direction upon to implement the order of 22nd March 2005. This was your prayer.
Yes.
Now, modified High Court order is at which page?
High Court's order, my lord, and start from 105 of volume 2.
105.
The relevant portion, my lord. Because 2 of the original application clubbed together and disposed commonly. So therefore, my lord, I am stick on 1005 only.
1005.
The 2 original application was commonly disposed of by the Honorable Tribunal. Therefore, this matter was challenged before the Honorable High Court. In 1005, this matter, the operative part of the tribunal was ditto affirmed.
Where is the tribunal order?
Tribunal order, madam, yes. Your Lordship, kindly go to page 83, from where the entire discussion has taken place with regard to...
Show us the order.
Yes.
This is AI bar railway person, so it is regularization.
Yes, madam.
Where is the operative portion?
Operative part, madam, that is...
Para 10.
Yes, madam.
Origin are hereby disposed of with a direction upon the respondents to regulate, consider engagement of who were working as railway. So this has been complied with.
Yes, my lord.
Now High Court modified what?
High Court, because my lord, here your Lordship, on page 86, when the, para 10, that there is a discussion of 2 application. Application number 2 and original application 105. Now come to the Honorable High Court's order. What the Honorable High Court? Kindly go to 105 of volume 2.
Modify the order of the passed by rejecting other part of reserve.
Just I'm reading the last paragraph.
Yes.
We therefore modify the order passed by the learned tribunal by rejecting the TA.
Yes.
The other part of the order of the tribunal in OA number 1005
so
of
rejection was set aside and you were directed to comply giving the timeline.
So far as the transfer application is concerned, my lord, it is with regard to the other applicants.
The other application, it has been affirmed.
No, it is TA02, my lord, it was rejected. My application 1005 affirmed.
Was not interfered with. That was not modified by High Court.
Yes. Yes.
We understood your point.
Yes.
Now tell us what is you have been regularized now.
Yes. I regularize the effect of the 1998 application which I made before the tribunal that was disposed by the tribunal in 2025 after the High Court order, where they preferred an SLP before the Honorable Apex Court.
Go slow, go slow.
Yes.
High Court order, then what happened?
High Court order, my lord, after getting the High Court order, they preferred an SLP.
Yes.
That is as page 108. 2 SLP. Page 108. The order consists of 2 SLPs. The one SLP, my lord, with regard to the petitioner, TA02, and the second SLP preferred by the railway against the our order.
Yes.
This SLP admitted and without any...
Which is your SLP? Number? Are you Shivcharan Mosha?
No, I am Anes Sheikh.
Where is your SLP order?
Civil Appeal 4467 of 2007.
Kothay? 44? Yes.
Yes. This is here by the railway was the appellant.
Mr. Bhushan, tell us what was the direction of the tribunal.
Tribunal, my lord, that your lordship has seen that.
What? I have not seen. I have seen, I don't find it out.
Kindly come to page 86, your lordship. That is the tribunal.
What is the direction? Regularize.
Regularize.
Then what is the problem?
Regulation, my lord, given into effect of the 2017.
Where is that in paragraph 10?
I am coming with the order, how the order dealt with. How this particular point has taken in the impugned order, my lord.
Disposed of with a direction upon the railway to regulate, consider the engagement of the applicants who are working as railway parcel porters in accordance with the Supreme Court judgment.
The Supreme Court judgment came into existence.
Show us how this regulation which has been implemented, which has been which has been, you are aggrieved.
Yes, my lord.
What is your grievance when this tribunal?
Kindly
has-
come to internal page 9 of the order impugned. It is at volume 2. Last.
পরিষ্কার করে তো বলবি। You showed us page 186, the direction of the tribunal.
That tribunal
Two
order
sets
has
of-
already been dealt by
sets
the
of
Honorable
parcel.
Tribunal in the subsequent litigation.
Sir Bhushan, two sets of parcel. One held license and other would not hold such license.
Yes, like us.
Like you.
Like us.
You did not hold the license.
License, my lord, the license are the parcel porter basically.
License to act as a parcel porter.
Yes. I was the unlicensed parcel porter, so therefore the absorption was taken place with regard to us. The original application filed by us in 1998, that was disposed of in 2005, that was challenged before the Honorable.
আরে ভাই, from when you were regularized? You were regularized from which date?
2017, you'll also.
Give us the date.
Yes. Page 1110. 1110. Page 1110, you'll also.
দুটো লাইসেন্স আর
আরে আমরা ওটাতে যাবো কেন? কি ভুল হয়েছে?
Yes.
Yes, show us your Anish Sheikh.
In obedience of, yes, in obedience of such and such, the following parcel handling porter of Badharwa station were screened by the committee, result of which we know. Then after my lord, kindly come to 10110, where I appointed as a parcel porter in the year 2017, at the verge of my retirement. So attaining the age of
Where is 2017? Date you are getting? They appointed as parcel porter, IS payment and posted.
Yes.
What is the date of this order?
1/5/2018, kindly in obedience of the Honorable Apex Court
So
order.
date of effect of regularization was from which date?
1/5/2018.
1/5/2018.
Yes.
Yes. Now how you are agreed?
Yes.
After this was done, order of tribunal was complied with. By 1/5/2018, after disposal by High Court.
After the dismissal of the SLP by the Honorable Apex Court.
SL.
Yes.
Now how you are.
So I took the point that doctrine of merger does not apply in the instant case. When I filed my original application before the Honorable Tribunal and that was allowed in 2005, my regulation should be take place from the date of the order of the learned tribunal. That is my submission. And the subsequent prayer which I have made, the notional appointment and where the learned tribunal balance. What
your order was directed to be complied with within 6 months.
Yes.
Now the tribunal's order was passed on.
Tribunal order passed on, my lord.
Tribunal order was passed on
22nd March of 2005.
22nd March 2005.
That is at page 79.
Now against 6 months will take you to 22nd September 2005. Now High Court matter was pending, SLP was pending, SLP disposed of on 1st March 2017. SLP was dismissed on 1st March 2017. Thereafter, they gave you regularization with effect from 18th January.
Yes, but that is from screened on 1/3/17, 1/5/2018. 110, page of 110, the second paragraph.
5/2018 regularized. So you are saying that you should be regularized by 22nd September 2005.
That's
and not by 1/5/2018.
Yes, and I should entitled to.
So why didn't you argue that point in the tribunal?
I have argued.
So
yes. Page 163.
Where is your argument? So
yes, correct.
Order impugned.
Kindly come to internal page 9 of the order impugned. How the tribunal has dealt my contention. May I read your lordship?
Which paragraph?
Para 8 onwards.
Please.
Yes. This tribunal, by a common order, allowed in TA number 02 of 2003 and OA number 1105 of 1998 on 22nd March 2005. Both the above mentioned applications were filed praying for regulation of the applicants. In TA 02 of 2003, applicants were licensed.
Page 9, okay.
Page Mallet, internal page 9. Yes. Just a minute. Applicants were licensed. TA 02 2003. The applicants were licensed porter of Badharba station, whereas the OA number 1005/1998 applicants were parcel porter engaged on casual basis. By its order dated 22/3/2005, this tribunal directed the respondent to absorb both set of applicant in regular appointment. This order was challenged in the Honorable High Court by Calcutta by the respondent in WPCT 518 of 2005. The Honorable High Court, by its order in WPCT 518 of 2005, dated 27/3/2007, set aside the order of this tribunal with respect to the applicants in TA 02 of 2003, that is Sivcharan.
Just set aside the order of the tribunal with applicants of TA. That was not set aside. High Court did not set aside.
High Court set aside.
Modified.
No. It modified with regard to in our contention 1105. But so far as the TA 02 is concerned, whereby the tribunal has passed an order to regularize, the High Court say no, you don't have any locus to regularize because you are working as a licensed parcel porter. So therefore,
read.
I will coming to your lordship for the clarification of that mallet, Honorable High Court's order. Kindly, I'm just resubmitted the same mallet, High Court order. Kindly go to mallet page 105 of the Honorable High Court's order.
No, you first finish it off.
Yes.
Set aside by its order dated 27 March, set aside the order of the tribunal with respect to the applicants.
PO 02 of 2003.
You have nothing to do about
nothing.
That. No.
I was not in that.
License and
the license parcel
tribunal's order
and affirmed the tribunal's order with respect to the applicant in OA number 1005 of 1998. Where we are?
Very good.
That is the casual parcel porters. The order was challenged by the licensed parcel porter in CA number 4352 of 2007 and by the railway in CA 4467 of 2007. Both these CA were disposed of by the Honorable Supreme Court on 1/3/2017 by refusing to interfere with the Honorable High Court's order. The respondent in CA number 4467 of 2007 were the applicants in OA number 1005 of 1998 as well as the applicant in this OA. They have been granted regular appointment on 7/5/2018. It is their case that their absorption in regular post should be antedated to the date as per the order of the tribunal in OA number 1005 of 1998 passed on 22/3/2025. The short point to be decided in this OA is whether the appointment of the applicant should be effected by the respondent from the date of the tribunal order in OA number 1005 of 1998.
Come to para 11.
Yes, ma'am. The effect of the above quoted orders is that the original order of the tribunal in respect of the contract parcel porter, that is the applicant herein, has been affirmed by the Superior Court and hence hold the field. By its above quoted order, the tribunal had directed the applicant to be absorbed on regular post within 6 months of the order. This timeline was extended by 3 months by the Honorable High Court by an order dated 27/3/2007.
Yes.
It is therefore stand to reason that the applicant should have been regularized latest by 27/6/2007. That is 3 months after the date of the Honorable High Court order.
When was the High Court order passed?
The respondent have taken a plea that order of the absorption.
2007.
27.
Dismissal of civil appeal number such and such on 17.
Yes, High Court order was passed on
27/6/2007.
27/6/2007.
27/6/2007.
6 was 27 March 2007.
That is wrong in the.
No, Mallet, that is wrong recording. Mallet.
You come to page 98, 95.
95, yes.
It is 7.
Yes, Mallet.
Huh?
Yes. There is a error in it.
চোখ কি করে খারাপ হবে? মার্চ তো ওয়ার্ডস এ লেখা আছে। মাথা খারাপ হচ্ছে, চোখ খারাপ। Yes.
Yes, Malik. Then I'm concluding, Malik. Benefit of the yes, while appealing against
It therefore stands to reason that the applicant should have been regularized from 27 June 2007.
yes,
Very good.
the applicant
Srinivas
will be-
Madhida, respondents have taken the plea that the order of absorption became effective only after dismissal of civil and. No, this observation is wrong. Became effective.
না না ওটা হবে না।
While appealing against the orders during a superior court is the right and prerogative, bojo. Benefits of time taken in deciding the appeal cannot be claimed by the respondents in deny. Yes, sir. এ কি বলেছে? ঠিক বলেনি।
My lord, just my lord, yesterday we have received the brief. We have to take instruction.
এতদিন পরে, এতক্ষণ পরে এটা জিজ্ঞেস হচ্ছে অর্ডার অ্যালাউ করে দেবে সেই জন্য। This reasoning is not acceptable, sir.
See,
You will prefer appeal and I will suffer.
Yes, yes.
নিজের নাক কেটে পরের জাত যাবো।
and kindly the one
Take your seat.
one point, Malik. Just I'll finish and I'll take my seat. And I'm only, Malik, they kindly go to the penultimate paragraph, Malik. Fourth line. The applicant will be entitled to all consequential benefit except the difference in wages for the period they have not actually worked as regular employee. There is no question that, Malik, I can work with a regular employee. I have got nothing. After 2 years, Malik, I got attain the age of superannuation.
No, who
That
has
is fine.
given power to modify?
All consequential benefits. Where is the direction? Tribunal direction?
The direction, Malik, at para 12,
Tribunal
1,
can
3, 4, 5, 6,
benefit.
7th line. 7th line.
Page?
Internal page 12.
No, that is the order.
86.
Page 86.
Page 86, grant due benefit.
Grant due benefit.
Yeah.
Accordingly.
And
High
Court says
High Court অন্য কথা।
only time extended
Yes.
3 months.
Yes, only that, this much.
Order is modified regarding the
Execution of time.
Extension of time.
Nothing else.
Nothing more.
Now that all consequential benefits, where it is taken, where it is written that in the tribunal, while appealing as a judicial and superior.
Then due benefit.
না ও বললো না all consequential
হ্যাঁ, ওইটা
benefits.
তো করে দিয়েছে এটা মডিফিকেশন হয়ে যাচ্ছে তো সব যে অর্ডারটা সুপ্রিম কোর্ট কনফার্ম করে দিল সেটা মডিফিকেশন
না, সেটা modification বলে দিচ্ছে তো।
এই যে রেসপন্ডেন্টস আর দেয়ার ফর ডাইরেক্টেড টু অ্যান্টিডেট দ্য অ্যাপয়েন্টমেন্ট of applicant notionally from such and such date from 27th June 2007. The applicant will be entitled to all consequential benefit except the difference in wage. A tribunal has modified all the order passed by the Honorable High Court, thereafter Honorable Supreme Court, tribunal modified. What is it?
give me some time so that we can take instruction next week.
Applied our mind. Applied. Do you have any substantial point to argue or?
Yet, my lord, authority, we have to take some instruction. If they give any instruction,
Affidavit of service as file be kept on record.
matter, my lord.
We are fed up with this, Mr. Bhatt.
I understand, my lord, but I tell your lordship, my lord, this is the SLP has been regularized, defect cured. My lord, these are the number, my lord. Kindly accommodate me, please, my lord, only for 2 weeks.
SLP against which order?
My lord, what happened, my lord? Initially, the challenging the order of dismissal, and SLP was filed. That was dismissed in limine. Thereafter, a review application has been filed, which was dismissed. Challenging the order of the review application, my lord, this SLP has been filed, my lord.
My lord, rejecting the review. Thereafter, my lord, Mr. Dev was appearing in this matter. Your lordship always insisted that to resolve the matter because it is pending since 1995. And my lord, the order was passed.
When is the SLP fixed?
My lord, the date has not yet been given, my lord. I have been instructed just to, my lord, pray for 3 weeks' time, my lord. Meanwhile, my lord, if I am unable to obtain the stay order, my lord can proceed with this.
My lord,
matter.
last occasion, your lordships
Because
observed.
what happened, my lord, due to these changing circumstances, my lord, the earlier learned advocate who filed the matter, my lord, that was defective, it was not cured. Subsequently, my lord, the new advocate appointed on, my lord,
Cannot be a ground, Mr. Bhattacharya. Mere filing of SLP is not a ground for stay of the
certainly, my lord, but
and
I'm just
that
praying
is
for
why
short accommodation of, my lord, but I understand, my lord, that
we gave you that accommodation last time.
yes, your lordship, and directed me to serve the DLR, my lord, who is also responsible for disobey of the honorable court's order, my lord. And the new incumbent was served and service was effected.
But kindly accommodate me, my lord. I understand, my lord, the condition of the petitioner because he is fighting since 1995. I'm only praying for 3 weeks' time, my lord. Meanwhile, my lord, if the state is unable to bring the stay order, my lord, any interim protection, my lord, certainly, my lord, can proceed with the matter. But kindly accommodate me for only 3 weeks, my lord.
My lord, kindly see the last order, your lordship is of the view that unless you bring this stay order, your lordship.
Sir, we are going through our order.
My lord, much obliged, much obliged.
I don't understand. Correction.
2026.
Yes. Uh, 10th of July.
Told him to bring the original records. Then Mr. Chakraborty was appearing. He brought the original records. He was present when we dismissed the review. It has a, you don't know because it has a long drawn history.
As I, my lord,
Charan, they appeared, not Mr. Chakraborty.
But my lord, I just only accommodate me for 3 weeks, my lord. Meanwhile, my lord, after 3 weeks, my lord, necessary direction can
Yeah,
be.
you ask them to appear online. We want to see them. If you obtain stay, it is okay.
My lord.
Or we can give you 1 week time, you can come.
I have my lord, specifically inquired, my lord, within 1 week, my lord, not possible to bring the order from the Supreme Court, my lord. At least, my lord,
How long? It was in July.
it was, my lord,
7 July we passed the order.
no, my lord, the new learned advocate appointed as
So
per,
we have given already 4 weeks time. Your SLP was filed prior to that.
my lord, it was rectified, my lord, 21st of July 2026. The new number has come.
Rectification, the defective petition was filed. That is why rectification. No?
Yes, my lord, defective petition filed.
State
The
should
new
be-
advocate come on, my lord, 10th of July, and my lord, the rectification, my lord, made on. So, my lord,
Rectification made on
my lord, 21st. No, 21st. My lord, after 10th of July, my lord, not 21st, my lord, after 10th of July. Kindly fix any date, my lord, in the mid of August, my lord. Meanwhile, my lord, if the my lord, we are able to bring this, my lord, any order from the Honorable Supreme Court, otherwise, my lord, that necessary implication will follow, my lord.
How
But
long
the
these?
alleged contemners,
Now, my lord, new incumbent has come, my lord.
he has served. No? Who is the contempt?
My lord, content number 1, 2, 3, my lord, that is DLRO, SDLRO, and my lord, the BLRO. On the last occasion, they have provided us the, my lord, the name who was changed, and my lord, immediately we implemented him as my lord, alleged content number.
Again,
Again,
Then my lord, we have served.
again, there is a change, my lord, on 21st
on
of
that date, Bipot Tarun Kormokar was the BLNL.
My lord,
You have
my lord,
incorporated.
we have served all the.
You have incorporated in the cost title.
My lord.
Where? Contempt petition is with us.
We have incorporated, my lord, time to time.
কর্মকার SDLR তমাল চক্রবর্তী.
My lord.
But my lord,
on that date, it was stated to us. And district land and land review officer who are now is
now, my lord, now, my lord,
District land review is Mr.
change, my lord. Now, my lord,
Yes, he was implemented. Your junior has given the name.
That 21st of July change হয়েছে।
হ্যাঁ তাই তো তারপরেই তো করা হয়েছে আমরা করেছি।
On 8th July, he changed the DLR.
Now, after thereafter on 21st of July,
21st of July, what has happened?
my lord, the next new DLR has come, my lord.
Oh, he is not the DLR.
No, my lord, I have the circular, my lord. I can share with him, my lord.
এই করেই ছড়ি দিত।
এখন হয়েছে আপনি বলছি।
SDLRO, who is present SDLRO and BLRO, Mr. Bhattacharya? Who are the present SDLRO and
So far as my lord, the BLN, LRO and SDLRO is concerned, my lord, I think my lord, they are the same because I have no such instruction, my lord.
on that date it was stated.
But so far as the DLN, LRO is concerned, my lord,
না না এই যে অ্যাড করেছে এই যে অ্যাডভোকেট সুনীল
রোহন লক্ষ্মীকান্ত
10-12
যোশী
2025
উনি আছেন
Yes.
উনি তো 21 তারিখে জয়েন করেছেন।
ওই তারিখে আপনার জুনিয়র নাম দিয়েছে।
ওনার তোমার
ভালো কথা।
My lord, the DLRO remain the same, my lord.
এখন
এইটা হচ্ছে সার্কুলারে দেখুন। আপনি যদি চেঞ্জ করে দেন ঠিক
as on date, who is the BLRO and SDLRO? And who is the ADMLR? Well, that means the DL and
My lord, the DLRO, my lord, who is changed.
Who is the present BLRO?
BLRO, my lord, that is
That we can also see. We are asking you.
my lord. Present BLRO is my lord, Bipot Tarun Konar.
That was in December 25. Has there been any change?
No, my lord. So far I know, my lord, there is no change. And last time, my lord, they said the DLRO was changed, and the my
Now
lord, the order.
this DLRO has again changed.
No, my lord.
Rohan.
This is the circular of 21st of July 2026. Now, my lord, the
This Joshi is not there.
Joshi is there.
Joshi is there. So very good. He has been served.
And the next,
Joshi ki will
My lord,
This is our
I am for
petition,
the respondent, my lord. I have little submission before your lordship. My lord, respondent is out of session in connection with his mother's illness. Yesterday in the late afternoon, one neighbor has received the petition. I hope to receive that within a couple of days.
You are Union of India. You are Union of India.
No.
Then
We prepare the application.
oh, you are Shankar Jha.
Shiv Shankar Jha.
Shiv Shankar.
His mother is bedridden, my lord.
Very good. Tell us what do you want? What do you want, sir?
I want 7 days time, my lord. I need to see the petition, my lord.
My lord, kindly.
7 days time is sufficient, my lord.
7th August.
My lord.
Okay, my lord.
Yes.
No.
What is the case? What is the matter?
Lord, excess payment. Lord, excess payment, postal staff, excess payment.
No, it
We
is.
are deducting their excess as such.
7th August. We will hear you on 7th August.
My lord.
Yes, next. 19, who is there?
Nothing but the state, my lord.
Lordship, there is a demise in the family of the learned advocate on record. The brother passed away. So I was just praying for an accommodation.
We keep it on 20th, 17th August.
After 20th, Lordship.
Eh?
If your Lordship may kindly please to keep after 20th of August.
After 20th. Chalo, ঠিক আছে, 24th August.
Lordship. Great.
An adjournment has been prayed for on behalf of the
Jyoti Tiwari is appearing in person in the matter, my lord. He is the petitioner in that matter. My lord, he has asked me to seek for 1 week's
Where is
adjournment.
Mr. Torun Jyoti?
My lord, he has not able to come before this honorable court today, my lord. That's why he has asked me to seek for an week's adjournment, my lord.
We keep it on 24th. 24th August. An adjournment, ওই same order করে দেবে. An adjournment has been prayed for on behalf of the check করে নিও petitioner না petitioners.
Petitioner, my lord.
So Mr. Roy, learned
government pleader.
Learned government pleader enters a
I beg to appear for the petitioner.
121, my lord, I'm being led by Mr. Billadal Bhattacharya, my lord, learned double AG in this matter.
My lord, if I shall place the case.
You have,
my lord, we haven't received the instructions yet, my lord. I'll seek for 1 week's time, my lord, if possible.
My lord,
recruitment
my affidavit of service.
Declaring that provisions of West Bengal police control.
Yes, my lord. The recruitment rules, which are not in consonance with the Transgender Protection of Rights Act 2019, my lord.
To let them file affidavits, madam.
Yes, my lord.
Acha, the present writ petition.
Wait, please, Your Lordship. I'm for the opposite party. Private respondent. My
Respond.
Lord, I'm for the private respondent.
Petitioner take 22.
My Lord.
No one appears. Dekhi file ta dao. Your for respondent number?
My Lord, 5, 6, and 7.
Petitioner. What is their grievance?
My Lord, the allegation against me is that I have low income and high expense. My Lord, I am my Lord, councillor of ward number 27. Allegation against me is that I have purchased a lot of property during my tenure.
No one appears on behalf of
Facts of the matter is that the private respondent that I have stated in these petitions is till today holding a post of municipality. And as he is holding a post of municipality, being the ex-ruling government, my allegation in the petition is that being holding such post, he has made some unwarranted profit and means of others' income, non-generated income, by holding that particular chair. And accordingly, being a responsible person and citizen of that.
Sir, what are any documents in support of
Yes.
your what are the documents in support of your allegations?
Yes. My Lord, the affidavit that he has annexed an election as he was a nominated candidate. If your lordships kindly compares the assets that he had at the time of when he was entered into, step into the shoes of politics, the capital and the asset that he had, page 20.
Yes.
Start from page 18 is that affidavit to be furnished by the candidate along with the.
That is at the time of 2020. Which election is this?
With this election.
Bidhan Nagar. This is a municipal election.
Municipal election.
When it was held?
My Lord, the municipal election was held 2022.
2020. Now, what happened in 2026? What happened?
By that time, the property that he gained start from page 25 onwards. These are the informations that I've gathered from government website. All the property are registered in the name of that particular person. Start from page 25 onwards. 25, 26, 27, 28, 29, 30, 31, 2. Well, it goes on.
estimated more than 5 to 8 crores.
How did you estimate that?
My lord, official valuations,
Official valuation list, where have you given?
my lord, official valuations I can't get. What I have procured from the government portal that these properties, Lordship knows better than me, my lord, Rajarhat and Newtown, all this area.
See, I am not the petitioner, sir. We are the court. How can I know?
My lord, right now the area Rajarhat, Newtown and all these places.
Don't make some submissions which are omnibus.
I'm sorry, my lord. All my lord, this area and my
So
lord.
what was his property when he had a bank balance of how much totally?
At the time of nomination, he had a valuation of 30 lakhs.
About 30 lakhs.
30 lakhs.
Now with 30 lakhs, he has procured property of 8 crores.
8 crore onwards. That I have got.
Sir, you are a
He is
rich man.
having several business.
Sir.
He is having several business. And apart from that, my lord, in this entire petition, there is no allegation of misappropriation of public fund.
No, not misappropriation. Today I am 10 rupees.
My lord.
In the next year, if I am having 1 crore,
My lord,
naturally.
he is having several business in his name, my lord.
So you disclose that, we will consider.
My lord, then I will on the next date I will bring documents relating to that.
No, disclose it before
Disclose
the
it in an affidavit.
My lord, I will.
File an
I
affidavit
will,
and
my lord.
try to meet his stand.
My lord, I will.
On the earlier occasion, my lord, he used to sell water. And after selling water, he joined that party and soon after.
Wait, don't. Sir, don't.
My lord, this is my abhorrence, my lord. That
Item 23,
My lord, I'm petitioner in person, my lord.
services, ওই আগেরটা affidavit of services file. Adjournment rate. You are in person. The
My lord.
matter of 2025. Armed Forces Tribunal. Oh, that tribunal is not functioning.
My lord, my lord.
That Mr. Trivedi said that your problem is going to end.
The Lordship will kindly take, I've been serving a copy of these instructions. Okay, what happened was, just in a nutshell, my lords, we had already taken, if my lords first place, my lord, the search cum selection committee had already, Lordship decided on appointments. If my lords kindly takes up the second page, my lords. My lord will kindly go through the first paragraph. On 2/9/2025, applications were received. The search and selection committee had come to a, but
Which
then there
page
was
are you- which page
the
are-
lordship, the second page of the instructions, my lord. First page is the letter, my lord, and this is the second page.
Brief status.
Lordship, the brief state, this is all, my lord. Nothing more, nothing less, my lord.
Circulated has circulated vacancies of 8 posts of judicial members, etc.
Then, my lord, there was an order of the Honorable Supreme Court. In the line of the Honorable Supreme Court's order. It was to be done under the Act of 2021, Lordship. So, my lord, therefore, it is taking time, but Lordship will kindly appreciate. My lords may keep it pending, my lord, so deems fit and proper, my lord. We'll get the exact status as of now. This is the whole problem which we face, Lordship, nothing.
No, now it was sent to.
My lord, we had, my lords, will kindly we see the fourth paragraph. It was sent as on
The
date
Attorney
of to
General.
the Lordship. It will be, my lords will kindly give us a breather, my lords. I will come up with a current report if my lord so deems fit and proper in the next month, because my lords, it's in the pipeline, it will be done, my lord. Just because it was done, but the Honorable Supreme Court, my lord, on 19/11/2025 came up with a judgment where certain recommended measures were given. So, my lord, in line of that, we had to again revisit the entire situation.
Mr.
I'm grateful, Lordship.
Good. Oh.